Hollywood Rent Stabilization Commission meeting of Thursday, September 12th, 2019 to order. Let's see, Commissioner Kirby, do you want to lead us in the Pledge of Allegiance?
Sure.
Pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Mr. Secretary, can we have a roll call, please?
You may. Commissioner O'Keefe.
Present.
Commissioner Kerpes.
Here.
Commissioner Maggio.
Here.
Commissioner Martz.
Here.
Commissioner Charity.
Here.
Vice Chair Topchian.
Here.
And Chair Bergstein.
Present. One second, sorry. She's done with the rebuttal. Okay, thank you. Sorry. Moving on to item 4, approval of agenda. Have we all had a chance to look at the agenda? And do we have any changes? Or if not, I'll entertain a motion to accept.
I'll move to approve.
Second.
All those in favor?
Aye.
Opposed? Okay. Item 5, approval of minutes. If we all had a chance to look over the minutes from our last meeting, which was the study session 22nd. Any corrections or changes? If not, entertain a motion to accept.
Motion to accept, or I move to accept.
I'll second that.
Okay. All those in favor?
Aye.
Opposed? Abstentions? Okay. Going on from item 5 to item 6, we do have a public speaker. Is it Joan Harp? I can't quite read. Is that Harp? Yes. Come on up to the podium. Yep, come on up to the podium. You'll have 3 minutes for your comments. If you could just state your name and city of residence for the record, please.
Thank you. My name is Joan Harp, and currently I'm homeless. I was a resident of 7219 Hampton Avenue. I was harassed out of the building by Michael DeBasso and his team. I contacted Rent Stabilization back April 1st when a fellow tenant tried to erect a chin-up bar directly under my window, which is not permitted because it's a historical building. I have text messages from the manager that said they shouldn't have allowed it, but they did. And when I went to Rent Stabilization, they did nothing. You can see, here's what they sent to me about the case. It has the wrong case numbers on it. Mr. DeBasso's has the correct. Mr. DeBasso gave me a 3-day notice for stomping around my apartment. The apartment beneath me was a garage, illegally converted. There was no insulation. He then continued to go on and take me all the way to eviction court. For what? In the entire time, I was in touch with Rent Stabilization, the counter window. I was there numerous times. I tried to explain what was happening. Sometimes I got a very curt response. And now I'm homeless. And what did the city offer me? They offered me a spot in Glendale in a co-ed shelter with men 10 feet from where I'm sleeping when I was harassed out of the building by men, and I'm a sexual assault survivor. How could this happen? How could this happen in the place where you're supposed to be the safest of all, where on the website it says, we protect tenants? I wasn't protected. And when I filed a slanderous suit and said to the Rent Stabilization Board, this happened to me, they found nothing wrong. By the way, Mr. DeBasso, after I moved out, will not give me my $3,600 deposit, saying I ruined the mahogany floors, even though they're the same photos used in the ad that I had. He's making $100 more off the apartment. That's what, 12 grand a year? And he has my $3,600. And by the way, I have a small claims court hearing for the 30th. They can't serve him. He's evading service. This is not a landlord, and it's a historical building. It's falling down around it. I'm not the only one he's harassing. How do I know that? Because he sent me other people's 3-day notices and talks about them being falling down trunks. How can this continue to happen? We're in contact with the city attorney. We had to get an attorney. It's going to cost the city money because it was wrong. Why did this happen? And why does it continue to go on? Why can't we resolve this? If I was your daughter, your sister, your friend, I'm sure you'd be darn mad too. Thank you for listening.
Okay, unfortunately, we can't take any action on items brought up during public comment. I don't know, Mr. Noonan, if there's anything you want to offer, any other staff members that might be able to assist or talk to her after the meeting. Thank you. Moving on to item 7, manager's report.
Good evening, Chair, members of the Commission. I'd like to take a moment to review the look-ahead calendar. Upcoming on September 26th, we do have a code amendment, which we've mentioned before. It, I think, was originally scheduled for this evening, but we moved it for at the request of the author. So this is alternative maintenance standards for designated historic RSO properties. As I've mentioned in the past, this is to address those buildings where our standard maintenance may be in conflict with the agreed to maintenance schedule that's on it in regards to its historic designation. We do not have any appeals that evening. If we do have time, we could look at scheduling another item that is one of your priorities, which you will be reviewing and confirming this evening. On October 10th, we do have an appeal scheduled that evening. That is also an opportunity for us, since we only have one appeal, to also look at adding one of those items off of your priorities. That concludes my report. As a final note, I'd like to just point out one piece of mail that you have in your mail folder, and it's from LA County, and it's for voting. The next voting cycle is going to look a little different. There's new voting booths. These are supposed to be and intended to be more friendly to all people of all accessibility needs and levels. So we're doing a mock voting session. It's going to be at Plummer Park. And the window of time, it's September 28th and 29th from 10 a.m. to 4 p.m. on those days there in the community center of Plummer Park. So the commission and anyone listening at home, if you're at all interested, hopefully we're all interested in voting, this is a great opportunity to come out and experience the new voting machines. That concludes my report.
Thank you. Do you have any questions for Mr. Noonan at this point?
A quick one, Chair. Benjamin, the September 26th item, there's no requirement for us to act or do anything, right? This is just receive and file, or would it require any action by the Commission?
Yes, it's also an opportunity for the Commission to provide any comments that they feel appropriate for the Council. Certainly, thank you for pointing that out. The RSO does not require the Commission to take formal actions on amendments of the code. However, this is an opportunity to comment.
Thank you.
Mr. Kirpies?
I didn't hear, or I didn't hear or see the answer that you gave, but will you be able to, either you or another staff member, be able to talk with the woman who spoke this evening after the meeting, if someone's around?
Yes, we've followed up with the speaker on several occasions and have had quite a bit of involvement with the speaker, and happy to check in with her afterwards.
Two other questions. Regarding the look ahead, still wanted to see if we could get that security deposit interest rate discussion on there at an appropriate time in advance of, or in enough time so if we did do anything, the council would have time to act as well. And then we spoke at the study session about having the city clerk come in and discuss issues of how to get items from this board to the city council. Am I remembering correctly?
Yeah, and I'm speaking with her about when she's available to come in. And so that will either happen on the next meeting, the 26th, or the 10th. She wasn't available at this meeting because of the event that she put on last night. She needed a moment to recoup.
And then did we get a response on the discussion about interest rates? Can that be agendized?
Of course.
Okay, thank you. Other questions for Mr. Noonan at this point? Okay, we'll move on to item 8, commission comments. Any commissioners have any comments at this point? Okay. Move on to item 9, an appeal, and that is D-4376, 7530 Hampton, apartment number 305. It was filed by the tenant, and I am going to apologize if I butcher anyone's names tonight. Ludmila Lukanova, are you present? Okay, you can have a seat. You can have a seat, ma'am. You can have a seat for now. And then is there a representative for the owner, Mr. Stanley Surratt? Are you present tonight, or anyone on behalf of the owner? No? Okay. So we will have a report from our staff attorney first. The commission will have the opportunity to ask questions of the staff attorney. Then you will have 5 minutes to speak. No rebuttal time. We do have one public speaker that will speak after you concluded your comments. So we'll start with staff.
Good evening, Chair, Commissioners. Jonathan Hall, of Staff Attorney. Tenant Ludmila Lukyanova has lived in Unit 305 since June 2005 and pays approximately $1,495 each month in rent. She filed an application for a rent adjustment based on the alleged removal of a parking space. The hearing examiner denied a rent increase and found that the owner had not provided a second parking space to the tenant. Hearing examiner concluded that there had been no elimination of the housing service, so no decrease was warranted. Staff recommends that the commission affirm the hearing examiner's decision. There is substantial evidence supporting the hearing examiner's conclusion that the landlord provided a single parking space as a housing service, not 2 parking spaces as the tenant's claim. The question on appeal is limited to whether substantial evidence supports the hearing examiner's findings. Substantial evidence does not refer to a quantity, but rather quality. That the evidence is of substance and that is relevant evidence that a reasonable mind might accept as adequate to support a conclusion. If such evidence is found, then the commission will uphold the decision, even if other evidence could support a different outcome. It is no consequence that the hearing examiner could have drawn a contrary conclusion had other reasonable inferences been drawn. A review of the record shows that there is substantial evidence to support the hearing examiner's conclusion on the appealed issue. Tenant applied for a rent decrease on the grounds that a housing service had been eliminated. Specifically, the tenant claimed that the landlord had provided 2 parking spaces as housing services and then eliminated the second parking space. A landlord-provided parking space is a housing service, the elimination of which would entitle the tenant to a corresponding rent reduction. A housing service is one actually provided by the landlord or agreed to by the landlord and tenant. The hearing examiner considered the evidence and noted that the tenant's testimony was inconsistent. On the one hand, she claimed that she had always had spaces number 4 and 5, but then she testified that she didn't get a second space until 2007 when they purchased a second car. She also testified initially that the landlord did not charge her for the use of a second space. In the appeal, the tenant cites a section of the rent stabilization ordinance that prohibits the removal of a parking space. Section 17.52120A states that if a landlord provides an on-site off-street parking space housing service to a tenant on or after January 1st, 2004, that parking space becomes an inseparable part of the rented premises, and the landlord may not remove it during the tenancy unless the tenant consents to the removal in writing. But here, the hearing examiner found the landlord had not provided a second on-site off-street parking space housing service to the tenant. Instead, the landlord allowed the tenant to temporarily use an additional space as a courtesy if one was available due to temporary vacancy. The evidence shows, and the hearing examiner found, that this was not a permanent housing service, but a temporary accommodation until the space was needed for a new tenant. Because the hearing examiner's decision is supported by substantial evidence, staff recommends that it be affirmed. I'm available for any questions.
Commissioner Kirpies?
So I understand that if a housing service is if a parking spot is a housing service and it's removed, there's one that can result in a reduction in the rent if that's a removal of a housing service. There's also the criminal aspect of removing a parking spot from a tenant. What are the enforcement? Are the enforcement mechanisms different? Does the city have a separate unit, maybe in code enforcement, that looks at the criminality portion, or do all of these go through a hearing examiner, and the hearing examiner determines, makes a determination whether it was a housing service, and then, depending on that answer, does the city look at potential criminal prosecution?
It would depend. If there was a question and it needed to be resolved administratively first, then if the tenant brought the cases in this instance, then most likely a conclusion would be reached through the administrative process first. The department also has the option of bringing its own department-initiated hearing in order to gather facts before going any further. To my knowledge, code enforcement does not make these investigations. It would be primarily a rent stabilization or legal services determination as to whether to go forward with the criminal prosecution.
And so is that a separate process, or when you say the administrative process, would you still be utilizing the hearing examiner, or?
Like I said, it depends. I mean, if we gathered evidence that there was clearly a parking space and the tenant had been deprived of it, then I suppose we could refer that to the city prosecutor with the evidence that we had. It doesn't have to go through a hearing. Given that we're discussing hypotheticals, I suppose it's possible it could start with an administrative hearing to figure out exactly what the status was of the parking space, whether it was a housing service or not, and then go from there.
Okay.
In that case, it would depend on whether the landlord restored it.
And
but-
that hasn't, as far as we know, that no other process, other than the process here in front of us, has occurred in this case?
No. No other process has occurred other than this process.
Thanks.
Mr. Holub, I probably need some clarification. Clearly, under the RSO, the service doesn't have to be in writing. This landlord can provide service verbally, and, which that is supported under the RSO, and any privilege can be also considered as a housing service. So here, I see the testimony by both parties that this was as quote-unquote courtesy parking space. So can that be considered as a privilege also, as a courtesy? Could that be considered as a privilege? As if it's a privilege, then that is a housing service provided by the owner. Because it's sort of like a gray line there, how you distinguish from a housing service from as a courtesy to park when the space is available.
If I'm understanding the question correctly, well, I'm not quite sure I understand the question. Are you referring to the situation in this case where the privilege was determined to be the right to occupy the space when it is
Correct.
available?
Yeah.
So that kind of privilege or amenity could be a housing service, yes.
Correct.
Okay. Right.
So then that didn't occur here. Or there was a temporary.
It did occur here in the sense that the tenant was permitted to use the space when one was available while a unit was vacant, but they were not granted a permanent use of the space, according to the hearing examiner's determination.
So that's my question. Where is that indication that there was no permanent use? It's just purely based on the testimonies, right? Solely based on the testimonies.
Well, my understanding is that it was based on the testimony and the lease, which the hearing examiner determined indicated a single parking space. Also, the application of the tenant for the rental, which indicated a single vehicle. So the evidence indicated a single permanent parking space, and the testimony indicated the use when the parking space was available because of a vacant unit, a second space or another space when it was available.
Okay. So now to clarify any further, if the landlord says you can park here when there is no car because the unit is vacant, so would that permission to park become a permanent because the RSO doesn't require to have things in writing? So that's the part I want to kind of
Not
tackle.
necessarily. I mean, if the parties have agreed on a temporary use based on the conditions of the property, then that's the amenity. The amenity isn't a permanent space. The amenity is the use of the space while the unit is vacant. So that's fine, if that's what's been agreed upon.
Okay, thank you. I just want to hear from the commissioners.
Mr. O'Keefe, no? Any other questions for staff at this point? Okay. Then the appellate, Ms. Lukinova, come to the podium. Just for the record, state your name and city of residence. You have a total of 5 minutes to speak. Come on up. Come on up to the podium where there's a microphone. Yep. And caution you that we can only consider evidence that is currently in the record, so if you try to introduce any new evidence, either the city attorney or myself will have to cut you off for that.
My name is Zina Zinnenberg, and
I'm going to bring the microphone a little closer to your face.
My name is Zina Zinnenberg, and I live in West Hollywood. I filed this appeal because it was very evident to me at my hearing that the hearing examiner assigned to my case was obviously biased. Prior to hearing my case, the same hearing examiner oversaw my neighbor's case, who filed for, sorry, I'm nervous, I don't like public speaking. Prior to hearing my case, the same hearing examiner oversaw my neighbor's case, who filed for the same exact injustice as myself. After the hearing was over, my neighbor witnessed Patrick, the representative for Stanley A. Surratt Trust, who owns my building.
I'm going to stop you right here. You're trying to introduce new evidence that's not on the record, not for this hearing. Okay?
Understood. The issue in question is that after a 14-year tenancy, my building was bought out by Stanley A. Surratt Trust. After the trust purchased the building, whether they were misrepresented by their realtor or failed to do their own due diligence, they came to realize that there were more vacant units than there are parking spaces. The trust realized that they cannot rent out vacant units and make their money back without at least one parking space per unit. And the only way that they are able to make their money back is by taking parking spaces from current tenants. The trust unlawfully took away one of my 2 parking spaces that I had for the duration of my 14-year tenancy. The trust has taken my parking space and has given it to a new tenant who is paying substantially more rent than I am. As clearly stated in West Hollywood Municipal Code 17.52.120, Section A, that is illegal. As per the rent stabilization ordinance, under the removal of parking spaces prohibited, I'm stating this verbatim, if a landlord provides an on-site, off-street parking space housing service to a tenant on or after January 1st, 2004, that space becomes an inseparable part of the rented premises and may not be, and the landlord may not remove it during tenancy unless the tenant consents to the removal in writing. As it is blatantly obvious by my standing before you tonight, I have not given up my space and do not intend to do so voluntarily. The Rent Stabilization Department at City Hall, represented by Peter Newman, had purposely misinformed me that I have no rights to a parking space unless it is explicitly written in my lease contract. Furthermore, they argued that the space was granted to me temporarily and therefore can be legally removed. There are 2 counter-arguments that I would like to bring to your attention. Firstly, there is absolutely no explicit requirement in the previously quoted law that a parking space must be granted in writing. Secondly, the aforementioned parking space has been in my exclusive use for over a decade, which hardly sounds like it was intended for temporary use, now does it? Moreover, the previous landlord granted me this parking space for permanent use on or after January 1st, 2004. Absolutely no part of their grant can be undermined or reduced by the state of the current law, which makes any attempt to remove the space by the current landlord clearly illegal under West Hollywood Municipal Code 17.52.120, Section A. Peter Newman and his office are therefore making unsubstantiated and counterfactual assumptions about the nature of my agreement with the previous landlord and are twisting the law to serve their needs, support a rich and powerful organization at the expense of the most vulnerable tenants. When I became aware of my rights under West Hollywood Municipal Code 17.52.120, Section 8, I went to speak to the hearing examiner and contest the injustice. The examiner dismissed my argument as inadequate. Moreover, the representative of the Surratt Trust, whom I only know as Patrick, alluded that the reason that I had that parking space in the first place was because my mother had slept with the previous landlord, Sean Tai, in order for this parking space and other favors. To my complete amazement and outrage, the hearing examiner, who was present during this exchange, did not bat an eye at this disgusting insinuation and insult. If this committee would like evidence, I do have a copy of the full hearing where all of this is clearly audible.
Thank you. Your time is up. Mr. Newton, do we call the speaker or do we take questions from the commission first?
At this point, call the speaker.
Okay. We did have one public speaker on this agenda item, Mr. Yuri Shamayev.
Yuri Shamayev?
Are you present?
Yuri Shamayev?
Okay, not present. So then we will, fellow commissioners, do you have questions for the appellant?
You moved in, what year? 2004? Is that correct?
Correct.
Correct, okay. And you began using the parking spot in 2007?
A decade ago from 2019, so that would be 2009?
2009 is when you began using the parking spot?
I believe so.
Okay. And did you use that same spot that through the...
That's correct.
All right, thank you.
Commissioners, any questions for the appellant? Thank you, ma'am. You can have a seat. We'll start our deliberations. Who would like to start? Richard? Commissioner Maggio?
I think the participant did not finish that section of the ordinance, which is unless otherwise agreed to by the landlord and tenant. Where I find it somewhat perplexing is the fact that she had this parking space for 9 years is kind of a long time to have that parking space. I think I'm going to leave it right there for a moment and then see what my fellow commissioners have to add to that thought.
Commissioner O'Keefe?
Yes, so as a appellate body, our role is quite limited. If there is substantial evidence to support a hearing examiner's decision, we have to uphold it. We don't reweigh evidence or if there's contradicting statements, even if there's substantial evidence to support it, we have to uphold it. The hearing examiner found that the resident manager, when Ms. Lukanova, and I'm sorry, I'm mispronouncing the name probably, that she credibly testified that one parking space was provided per unit, and there's also in our record one license plate. So essentially the hearing examiner found, based on that testimony and hearing all of the testimony, that there was a temporary use of the second space, that it was only while there was a vacancy. Because there was no longer a vacancy or any vacancies, all of the spaces were taken up. And so I think we would have to uphold the decision if there's substantial evidence, and we found before that a witness's credible testimony is substantial evidence. It's not our role to weigh the credibility of witnesses as an appellate body. We don't have that authority. On page 30, what Commissioner Topchin was asking about was addressed. It says that administrative precedent recognizing a housing service, including the right to have ... and that she was allowed to use a second parking space until it was needed for another one, that was the housing service, and that according to the record, that hadn't been taken away because once there's a vacancy, she was not allowed to use it. When there is a vacancy, that temporary use would be taken away. 9 years is a long time for using a space temporarily, but with a lot of vacancies, the circumstances have changed. Further, although this isn't really relevant as long as there was substantial evidence, on page 26, the hearing examiner found that the testimony was inconsistent by the tenant, saying at one point they always had 2 spaces, at the other time they had the second one as of 2007, and another time that they'd had it for 10 years. So the hearing examiner, not us, is responsible for deciding the credibility of witnesses, and after hearing all the evidence, they found that it was a temporary use, not permanent use, and therefore I would have to uphold the hearing examiner's decision, although certainly we can have sympathy for the situation.
I had quite a bit to say, but Commissioner O'Keefe took all my words, so I will just echo what you said, and I think you explained it well, and I think all your points were correct, so I would uphold the decision even if we don't think it's fair or right. I think you explained the reason we have to.
Yes.
I have a question for legal counsel. Is there a way in which the commission could uphold the hearing examiner's decision without confirming that there was not a crime, or that without preventing her from having an investigation done or her going to court and saying that this was a criminal removal of the parking spot? Because where I'm at is I agree that we can't overturn the hearing examiner because she, based upon the evidence in front of her, and I understand where she came to that conclusion. However, the evidence also suggests to me that this was not a temporary agreement, that this was a long-term agreement, and it should be looked into by another body if there's another mechanism. I don't want to do anything that precludes her from the city being able to look at this in a different light.
I don't think the commission can do that. That would be an inconsistent determination.
So as I understand it, and I have to look at where exactly this is codified, but our role is interpreting the rent stabilization ordinance. Is the ordinance that the tenant cited part of the RSO? Because ours is if a housing service has been taken away, and I thought the statute reference was a different statute that arguably could be interpreted differently.
The question is whether that provision is part of the RSO?
Specifically the part of the RSO that has to do with the remedies that we're administering, that are administered by the Rent Stabilization Commission for reduction of housing services.
No, it's a different section.
Just one more question. Do you know if it was enacted at the same time or at a different time?
Later.
Okay, thank you.
Commissioner Charity?
I'm also in agreement with Commissioner O'Keefe. I thought she summed it up really beautifully. We are an appellate body, and we have certain rules we have to abide by, and I can't find the hearing examiner's decision clearly in error. I think there is substantial evidence on the record supporting the decision, so I'm also in favor of affirming the hearing examiner's decision.
Commissioner Modger, do you have any further comments?
No, except that I'm still, I don't know if I'm annoyed or bothered by the 9 years, thinking that something is used for 9 years, and then suddenly you're told that this was temporary. I guess you could say that. Again, everything really has to be in writing. I think that's always your best bet, and that protects you. I believe our hands are tied here, and we will have to agree with the evidence that the hearing examiner has established. So I'm going to have to support the resolution.
Vice Chair?
Well, I was a little bit turned about the decision because in my opinion, the question was whether the second parking space would constitute a permanent housing service or not. But based on the evidence and the testimonies by the parties, I don't believe that the examiner erred. I mean, it could be that other testimonies or evidence if it was provided at the hearing, a decision could be a different decision made by the examiner, but whatever decision was made by this examiner, we cannot substitute it by our own, because I see that based on what the examiner had before her or before him is supported by the record evidence, and I have no choice but to support the affirming the decision. Thank you.
So I'll also be voting in favor of upholding the hearing examiner decision. There is ample evidence in the record to support that. On page 26, Ms. Zinnenberg initially stated that they always had spaces 4 and 5. Later said that didn't happen until 2007 when they got a second car. And she stated on the record at that point, Mr. Tsai, T-S-A-I, the prior owner, said they could use a second space, and that's a direct quote, and he was kind enough to give her permission to use the second space. Giving permission to use the space is not the same as providing a housing service, and it's not assigning a parking space that will go with the tenancy. The testimony on page 27 about the agreement between the appellant and the tenant in apartment 202 that they can use that parking space out of town is irrelevant to tonight's hearing. That is an issue between two tenants and nothing to do with the landlord. On pages 27, 28, and 29, the assistant manager, Nusa Novic, I apologize if I'm butchering that name, also testified that the prior owner allowed tenants with a second car to use, again, that's a direct quote, a second space if one was available until such time that a new tenant moved into a vacant unit. It was not assigned to them. I think it's a little unusual for a building of this size to have 6 units vacant at the close of escrow, but that certainly is an owner's prerogative to not rent an apartment. There's nothing illegal about that, so I'm a little troubled by some of the discussion in this. It appears to me from the testimony that the prior owner was really kind of going out of their way to extend a courtesy to tenant, going, while we have these vacant apartments, these parking spaces are not being used, you now have a second car, you can use a second space. There's nothing in the record that indicates that that parking space was assigned on a permanent basis to the appellate. The lease, again, has been stated, states parking place singular, not in plural, doesn't have a number. It appears to me from the record the owner was trying to be a good landlord and trying to accommodate a tenant's wishes while that was available, and the tenant has misinterpreted that as being a housing service. So I would be voting in favor of upholding the hearing examiner's decision. And with that, I would entertain a motion.
I would support this, this motion if we don't have to change the resolution by any means, but I just want to emphasize that if we affirm the hearing examiner's decision, this does mean that when a vacancy occurs again in the building and you're denied a parking spot, you are then, the service may have been removed again. So keep that in mind, that we're not saying that you don't ever get to use another parking spot because you were offered a service and that service was using the parking spot if one is available. So keep that in mind in the future, and hopefully your landlord will realize that as well.
But just to clarify, the landlord would be under no obligation to offer a parking space.
Correct, but
She
she
could
could come
ask, it
back
could
and
be
file.
accepted or denied, okay? So you've made a motion, is that correct?
No.
Commissioner O'Keefe? Or
I will move to adopt Resolution RSC 19-5556, which affirms the hearing examiner's decision on D-4376, 7530 Hampton Avenue, Unit 305.
And I will second that.
Mr. Secretary, can we have a roll call, please?
You may. Commissioner O'Keefe,
Aye.
Commissioner Krupes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Charity,
Aye.
Vice Chair Topchian,
Aye.
and Chair Bergstein.
Aye. Motion passes. If you have any questions, feel free to approach staff at the end of the meeting. Now, ma'am, your public comment is finished. You can approach staff at the end of the meeting if you'd like. So with that, we will move on to item 10, new business, approving our priorities for the fiscal year 2019-2020. Excuse me, ma'am, ma'am, your time, ma'am.
And you were the only one who voted in favor of this law, who even said it's black and white. And it's just so unfair that all of you don't see this law as black and white because it is. Sorry for interrupting. Continue with your meeting.
We will. Mr. Noonan, do you have a report?
I do. At your study session, which was at the last scheduled meeting time on August 22nd, the commission reviewed priorities that it had set last year. These are desirables that the commission would like more information on and would like to explore. So it reviewed those, and the commission then, commissioners, independently voted using your dots on a set of priorities that you wanted to explore or potentially explore for this year. On page 41 of your agenda packet, we've provided the priorities that made the highest ranking, and we've set these up as we did last year and the prior year, and in blocks, groups of the A block, B, C, and D blocks. As you notice on the far right, we use a weighted score so that those items fall into the different sections. And so on page 42 and 43 are the additional priorities that you did entertain at the study session. However, I apologize. On page 42, they're just presented unorganized. And then 43 provides the items that didn't quite rise to the same level. So we've cut it off at 56% on the weighted score. Anything below that, we didn't add to the priorities. And so this evening is your opportunity to review these and to confirm if, in fact, these are the priorities on page 41 that you would like to go forward with. As an alternative, if the commission felt that another priority was you did want to elevate it up from a lower ranking score, you have that opportunity to do that as well. And I turn it over to you, Chair.
Thank you. Commissioners? Mr. O'Keefe?
Go ahead.
So one thing has come up since we set these priorities just 2 weeks ago, which is I believe the legislature is poised to approve statewide rent stabilization for any building that's constructed more than 15 years ago, or maybe 15 or more years ago. And that had me wondering if our housing services protections and minimum maintenance standards might be able to be expanded. I haven't looked at the bill at all. I don't know if that's the case. I think it passed both chambers and is going to the governor. And if so, I don't know if it's too late to add something to it, but if there was a consensus that exploring that would be a priority and if it would be legal, I wanted to put that forth either as part of the priorities or just separately as something we might want to have on our radar.
I'm sorry, I didn't quite, I know you were discussing the legislation that was just passed and it's going to the governor's desk, but how did that?
So my question is, with people who are subject to our own city's rent stabilization ordinance, of course, the city has enacted the rent stabilization ordinance, meaning that the housing service that once provided cannot be taken away. If this bill becomes law, which looks like it's poised to do, that wouldn't apply to any of these newer constructed buildings, anything that's not already under our RSO. So my question is if we could expand the part of the RSO that's about the decrease in housing services so that, say, if somebody lived in an apartment that was constructed 20 years ago, it's not covered by our current RSO, if we could say if they have the dishwasher taken away or whatever, that they're covered by it as well. So I guess it's a question, if you might not know offhand, but do you know if it's even something we could legally do, Mr. Holub?
Yeah, I'm not sure it even relates necessarily to the bill that you're referring to. I'd have to look at it more carefully. I understand what you're saying. You just want to talk about in the future encompassing more properties under the minimum maintenance standards. And for example, I mean, it becomes more tricky, I suppose, because we're not talking about necessarily, well, you're talking about the properties that now might become rent stabilized to a certain degree because of the potential for the bill. And we can look at that. I mean, we can definitely look at that.
Yeah, so I don't know if we want to, maybe it shouldn't be part of the priority, but at some point I'd be interested in us exploring if we can, because I think the philosophy behind the housing services is if a landlord's only getting a fixed amount plus a fixed increase, they could make more profit by taking away housing services, and the city has an interest in ensuring that that doesn't happen, that people aren't denied the minimum maintenance standards, and it might be worth, if we can legally do so, exploring if we can broaden those protections.
So how would a landlord be making more money by removing a housing service? I don't follow that.
Well, essentially, I'll show you, I can send you a court case, Sterling, where they have it more articulately stated, but essentially they get more profit if they don't spend as much money keeping up a business.
Maintenance issue.
Yes, or, a new washer, fridge, or whatever the case may be.
My recommendation, if the commission is interested in that, is to roll it into C as a specific item, because it kind of fits there. It's an update on state affordable housing policy, and if we can, instead of expanding this list, include it as part of that, is just my idea.
That's a good idea.
If I could interject an
Yes.
idea here. I just wanted to point out in B, there's an item which is to explore other forms of rental assistance for extremely vulnerable populations. That may be a little bit of an odd fit because of the vulnerable populations. However, I want you to know, whether it's on your priority list or not, if that bill does pass, my office is going to be looking at how we can administer that locally, because of course, as you realize, I think an open-ended question at the state level in total, in fact, is who's going to be overseeing this process? And I know locally, we already have a mechanism in place, which is the Rent Stabilization Office and our legal services that are very well-versed in rent stabilization. This is going to essentially expand the number of units that we can have some level of purview over. However, it may in fact be creating a different criteria which we can apply. And I hear you when you're asking how much of our local, our existing program can we apply to the new units. For one thing, for instance, we will not be able to apply the AGA to these new units. There will be a different AGA in place. So we will be looking at, since this is going to be in place until 2030, do we add those into our registry? And do we start applying some of those requirements of the registry to these units? Do we apply a fee? There's a number of different questions that we would look at. Mind you, the number of units that were built in the 90s up to the early 2000s is not that much. We've had much more development activity recently than we've had in that time period. However, there is a number of buildings that would fall into the category, and so we would certainly be coming back to the commission with updates on that process and inviting you in on these decision matters, whether it's on the priority list or not.
Thank you.
Just a quick one, Mr. Noonan, I think there's a typo in my, on page 41 under B. It seems like I gave C should be 0.5 instead of 15. I don't know if it's going to change the score. Yeah, and the same thing on page 42 for explore other forms of rental assistance. 1, 2, 3, the third graph.
So that's pretty major. Maybe they should want to come back with it in 2 weeks, since it changes all the math and the numbers.
I wonder if it changes the
Well,
overall.
again, if the commission does feel that this represents your priorities, you could certainly confirm it this evening. We can adjust the numbers, but certainly tonight is your opportunity to make these adjustments. For instance, if you feel that that item of exploring other forms should actually be in a C category, you can certainly drop that down to a lower category. You could elevate items up. You could leave it as is. Or certainly we can also return it in 2 weeks if you'd rather us just come back and recalculate the math.
Personally,
Let me finish with the rest of the commission. I'll come
Sure.
back to you, okay? Commissioner Kruppies?
I was, to piggyback on what Mr. Noonan was saying before about the legislation, and that was kind of my point about, it doesn't matter to me which order these things are in. If you look at page 43, the three things, not to list them in any priority or anything like that, but the first item, review RSO standard maintenance. The second item, limit in converting garages, homeless and affordable housing. Drop down to the fourth one, explore guidance on when there is an increase or reduction in natural light. Drop down about 3 more, review and consider revising the NOI calculation. And then the next one, review and update the rent stabilization regulations and ordinance. These are all things that the commission has the prerogative to bring up as an agenda item if it's important to us. So it doesn't matter to me as much about the order these are listed in, because if there's an important issue that I want to bring up, I will suggest it to the commission, and if the commission agrees, then I will add it to a future agenda. So I'm fine with the way it's listed.
Mr. Charity?
I'm also fine with the way it's listed. The things that are important to me are in the top categories.
Commissioner Maggio?
Yes, I agree. My interests are the first 5, which I think are presented correctly. There's so much. It's really all important. And I think it's kind of hard to do A, B, C, D. And but I'm happy, and I'm happy that we had a very successful study session, and I think we got a lot accomplished.
Mr. Vice Chair?
I'm not changing my priorities as long as it's corrected, so I'm fine.
Mr. Keith, do you have a further comment?
About Commissioner Topchin's comment on the math. I think it's the system that staff came up with. I thought was really fair to score it based on points with A, B, and C. And so, since Commissioner Topchin had voted for the forms of rental assistance as a C, which would be 5, then that probably would push it down to 60. And I think might as well change the math and have it appear there. So unless somebody wants to change their individual points and value, I think it's a very fair way of prioritizing it and just having it listed. Although, like Commissioner Kirby said, we could just propose an agenda item. I think it's worthwhile to have it out here and see what the body as a whole feels and reflecting the vote accurately.
Although it's possible he may have meant it as an A, not a C, because he's only got 2 other A's in the entire list.
How many
Could
A's
just
we
be a
had?
typo.
We had 2 or 1 A? I don't know who ran. Probably 2. Oh, 2. So then probably that's A. Then C should be corrected to A instead of 15 to 5. Because I have only 1 A under D section. Yeah, so then in that case, instead of C, it should be A15. That solves. Don't have to revise it.
I mean, it's up to you. Do you think of it
Well,
as A or a C now?
because I see, here I only see 1 A down there under B, under D. So logically, the second
I
A
think we're
would be
splitting
there.
hairs here. I think
That's
it
fine.
sounds that we have a consensus that we're okay with the way that they were ranked. I agree with Commissioner Kirpes. There are some that ranked lower that, if time allows during this next calendar year, I'd like to see agendized. I think I would ask from staff that if you could look at the top-ranked items and figure out which ones will take the longest for staff to prepare for, so that as we have slots open at our meetings, we can plug this item in, but this other item might take more time for you to prepare, and just let us know which one staff is most prepared to bring in with us. That make sense? Okay.
Just one additional comment. Since we're already on approval of the priorities, which I think we all seem to agree upon, for staff, has there been any more thought about moving the study session to January?
Staff's open to the commission's thoughts on that. This is your study session, and so if you feel it's appropriate to hold it in January, we're happy to move that and accommodate the commission at that time.
Does that work for the staff, though? I mean, is there a preparatory time, or?
I think typically January is a good month to have study sessions, and typically everybody's back from vacation, and there's I imagine that there may not be any sort of scheduling challenges that we ran into this summer.
Wait to hold off on answering that. Maybe we bring it back to talk about it at the next meeting so that we can combine that piece of information with when the appointments occur. I don't remember if there's one other thing that we had mentioned at the...
I think the election cycle.
Just to bring those 3 pieces of information together, it might be that we all still want us to do it on January, but it might also affect that. All I'm asking is if we can bring those 3 pieces of information together at once and then decide whether to move it to January or not.
I did have some further thoughts on it, but I think we really have to agendize it if we really want to have a full discussion on whether or not we want to make any changes or have a mini study session. So
Do we want to place that on our next meeting's agenda for a little bit more
I
full discussion?
I would appreciate it, and I would ask that we,
Commissioners, you okay with that?
Sure.
I'm seeing everybody's head nod, so can we add that to our next agenda? As an item to discuss whether we will be changing or adding dates for our study sessions?
Sure.
Thank you. That will go on to item 11, unfinished business. Continued discussion on our duties listed in Municipal Code Section 2.64.090, specifically for evaluating and recommending to City Council relative to the city's housing policies.
And would this one be better served when we have the representative here? Should we have the
City clerk?
Yeah, when we have the city clerk present.
I would agree. Commissioners?
I would agree.
Sounds good.
So can we move that agenda item to when Yvonne has time to come and speak to the commission?
So you want that item to be placed on the meeting when the
City clerk is here.
to answer
Correct.
questions?
Correct.
Okay.
Thank you.
do we want to make a motion to actually approve the priorities, the fiscal years of 19 and 20? I think we should make a motion. to
Do we
say
need a motion or is it a file and receive?
Well, we can make a motion to file and receive.
Mr. Noonan, do we need a formal motion to accept the priorities?
If you go ahead and just do a roll call on them as a confirmation that these are your priorities, what we're going to do is we will put these on as a consent calendar item for the council.
Then I'll make a motion that we approve the priorities that are listed here for fiscal year of 2019 and 20.
I will second that.
For a second? Yes. Mr. Secretary, roll call.
Commissioner O'Keefe,
Aye.
Commissioner Kirpies,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Charity,
Aye.
Vice Chair Topshian,
Aye.
and Chair Bergstein.
Aye. That will move on to item 12. Any public comments? I don't have any speaker slips. Tom, any more speakers? Thank you. We'll move on to item 13, commission comments. Commissioners have any comments for this evening?
I just want to commend the city of West Hollywood on a really great annual Congress. I really enjoyed the emergency preparedness section, and it got Commissioner Topshian and I talking about how we're going to get our earthquake kits together, and we really appreciated the 72-hour kit that was handed out. So just commending the city of West Hollywood. It was a great annual Congress.
So I'm going to step into my role as landlord and just make a few comments. It's been an unusual couple of months for me where I've assisted another rent-stabilized building landlord who's gotten up in years helping renting out a number of vacancies, and just some anomalies that kept appearing with applicants. So I'm kind of speaking to tenants who might be watching, that realizing it is still kind of a tight rental market throughout California, and best is to put your best foot forward when you're applying. I got a number of people applying that said that before they even saw the unit, I will be your best tenant ever. I needed a 30% decrease in rent. There's a better way to handle that, which is to come and meet the landlord, look at the unit and go, I'd love to live here. This is why I'd be a great tenant. I can't quite swing this, but on the first phone call, it kind of sets a bad taste when you're automatically asking for a reduction in rent, as well as a number of tenants that once their prospective tenants, once the background and credit checks were pulled, finding evictions, multiple accounts with collection agencies, and then to have those prospective tenants very upset that they weren't offered a tenancy. My advice in those, because things happen, finances happen, jobs change, medical bills happen. Again, put your best foot forward and explain to a landlord, before you pull my credit report, you're going to find these things. Let me explain to you what's happened into my life. Because we've made exceptions. I made an exception on someone on the rent once they explained their situation. But just to, the more information you give a prospective landlord, particularly in today's economy, I think the better chance you might have of getting a unit that you're truly interested in living in. That's my rant as landlord. Moving on to item 14, staff comments.
No comments.
Then with that, we move on to adjournment. I will adjourn to our next regular meeting of the Rent Stabilization Commission, to be held on September 26, 2019, West Hollywood Park Public Meeting Room, Council Chambers.